Good morning. My name is Danielle Blake. I'm Chief of Public Policy with Miami Realtors. And here we have Jessica Lowe with us from Broward, Palm Beach, and St. Lucie Realtors. So Jessica, do you want to introduce yourself and say a few words?
Yes, thank you, Danielle. Good morning, everyone. Welcome. It's so happy to see you all here. My name is Jessica Lowe. I'm the Senior Vice President of Programs for Broward, Palm Beaches, and St. Lucie Realtors. And I just want to thank our panelists, and I want to thank Danielle and Miami Realtors for allowing us to co-host this webinar this morning.
Thank you so much, Jessica. We also have Sean Brown and Allison Hurst with K. Bender and Rimbaum with us. They are certified attorneys in condominium, and I like to call them PUDs, planned urban development, but you don't have the urban in there, so just planned development. So we've got a lot of questions from the last couple years about the application process with condominium associations. What are the rules? What are they allowed to do? We also get questions about minimum credit scores a lot. And so we've spoken with you both ahead of time, and I know you have a PowerPoint presentation you're going to share with us and hopefully get some of these questions answered today. So I just want to remind our participants that if you have questions, please post them in the Q&A box. And then if you just want to say good morning or anything else, post that in the chat. Jessica and I will be monitoring both of those. And at the end of the presentation, we'll be asking Sean and Allison to answer the questions that you have. So with that, we'll get started. Thanks so much. Do you want to share your screen, Allison or Sean?
Yeah, let me do that.
Okay.
Okay, do you see it?
Yeah, it's there. Little need to scroll back up a bit.
Okay, perfect. Let me go back to slide 1 here. I'm sorry. I'm gonna have to just go back through it manually, even though it's a preview. I apologize. Okay, we're here, back to the beginning.
So thank you for everybody for coming. And to be candid, we want to be quick on this presentation. Our intention is to do it in about 30 minutes. We know there are a lot of questions on this topic. There are a lot of issues. There's a lot of horror stories. And we're here to help answer those and provide some guidance to the extent we can, but also just help you understand where things come from an association perspective. So first, just a bit about myself. I'm Sean Brown, K. Bender Rimbaum here in Tampa. So I'm a little outside of your area, but generally when I get involved in these things, it's because things have gone crazy and I'm being asked to blow it apart, or it's been blown apart and now my job is to come in and deal with it. So I'll let Allison introduce herself. You're going to deal with her more on the day-to-day type of stuff because she's there on the ground advising the boards. So Allison can explain a little bit about herself.
Hi, everyone. Thank you so much again for having us be here to speak with you. Again, I'm Allison Hertz. I'm kind of like a corporate counsel for condo associations. I am board certified by the Florida Bar in condo law. I've been doing this every day, all day, counseling boards for maybe 14 years or so. So I feel like I've seen it all. And, sometimes I am surprised as well from day to day at the things that do come across my desk. So as Sean mentioned, I think we'll get right into the presentation. We'll get through it, and then we can answer your specific questions that you have in dealing with the condo boards. This presentation is pretty specific to condo associations rather than HOA associations. So I just wanted to mention that as well. We might touch on the HOA association issues, but frankly, the condo law is more detailed, and I feel the condos are probably where you have more difficulties dealing with. So that is really the focus of today's discussion. All right, without further ado, we'll move forward. So Sean, back to you now.
So Florida is a very different place. And Bugs Bunny was right. We're our own little island off on our own little adventure. So condo associations. When dealing with a condo association, there are two options. You either follow my rules or you're going to follow my rules. No other choice. So how many of you probably feel when you're seeking condo association approval? This is kind of what I think I get from a day-to-day basis on that. However, we're here to help you. The key here is to learn how to speak the language of condo, and it is its own unique language. And that's our goal here, is to help you understand that language to be better informed and able to communicate with us. So we're here to help you. Bottom line, we're here to explain things and help you understand what exactly is going on when you go to that condo association to get approved for that transaction, whether it be sale or lease. So first issue, as we always know, is getting in contact with the association. And from the stories I've heard from many of you, I believe this sums up your interaction with a lot of associations is you can never quite figure out, who am I getting a hold of? How am I getting a hold of them? Well, there's a couple of ways to deal with it. So one is associations that are managing a condominium with more than 150 units must maintain a website. And even smaller associations, substantial majority, maintain their own website. So check for your association you're dealing with, look, see if you can find a website, have some contact information. Search the name for the association on SunBiz, find the mailing address of the registered agent. Often it's the management company, and if you find that address, then you can simply just go on Google, pull up the phone number, and at least have somewhere to go. Also note the FAR Bar condo writer is going to require certain documents to be provided, including year-end financials and the FAQ sheet. These are often going to have contact information on them for the association or its management company, so don't overlook that. I will note the FAR Bar condo writer does not provide for contact information for the association. However, glimmer of hope, I actually reached out to a member of the FAR Bar committee the other day and just sort of said, hey, this isn't there. And so they're actually going to think about maybe amending the condo and HOA writers to have a blurb now for insertion of association or management company contact information. They just sort of, amazingly, after all these years, it was an oversight. So where do condominium associations get their power? Well, Allison, where are we getting this power that we love to wield?
All right, well, that's the good question, because the authority to screen and approve transfers, leases, sales, and other types have to be set forth in an association's governing documents. The associations and condos particularly do not have any inherent authority to screen transfers. There's nothing really in the law. There's nothing in Chapter 718, the Condo Act, or Chapter 720, the Florida HOA Act, authorizing an association to conduct screening or approval of any transfers. The authority actually has to be specifically contained in a governing document of an association. There are many boards out there that we work with and that we don't work with that either have no idea that this exists or just try to look the other way. So that is very prevalent out there, and I see it all the time, where I'll have an association come to me asking me about the approval of a certain transfer and whether they feel that they have the right to disapprove or ask for certain information. And I look within the governing documents, and this association frankly has zero authority to do any screening or approval of any transfer. So that's the threshold issue I see with this entire topic. Number one, does the association have any of these authorities that it may purport to have? Sometimes a management company that you may be working with in terms of these transactions will be on autopilot. They'll have an application or some process that they've used for other associations or that they attempt to use for all of their associations across the board, and that this process just might not be authorized by the documents. So when I talk about authorized by the documents, what exactly does that mean? Which document, where, when, how specific does it have to be? And we won't go into excessive detail on this topic because that could take hours to discuss all of the specifics as to the authority issues, but we'll go through it really quickly because it is very important. The documents that you have within an association, governing documents I speak of, are going to be, number one, the Declaration of Condominium. That's the highest of authority in your condo world. Then you'll have your Articles of Incorporation, you'll have your bylaws, and then lowest on the list here, lowest on the totem pole, are the rules and regulations. And we see those thrown around a lot because they're really the most concise document, but they really have the least authority within the chain of documents for an association. Which document is the best? The courts have determined that the Declaration of Condominium is clothed with a presumption of validity. So when you look at restrictions within a declaration, they are going to be presumed essentially valid because that's the document that's recorded with the county. Everyone is on notice of these restrictions. Typically, the membership have approved any amendments to these documents, and therefore it is going to be pretty authoritative and legit, right? What is the second best document we see? Well, the second best document for a lot of these types of restrictions, transfer, screening, and some use restrictions are going to be the board rules and regulations. But the board rules and regulations can only take the association so far, because rules and regulations, according to case law here in Florida, cannot conflict with express provisions provided in the declaration or rights reasonably inferable from the declaration, and board rules must be reasonable. They must be reasonably related to the safety, health, and welfare. The bottom line with rules for your purpose here and what's relevant to you is if the declaration addresses a certain topic, a rule of the association cannot be contrary to that topic in the declaration, and it can't really, the rules can't expand rights that are not really authorized by the declaration. This is especially true of leasing restrictions. A lot of times we see in condo world, in my practice, that you'll have a declaration that does not address leasing whatsoever, but then you'll have a bunch of rules that seem to restrict terms and different things on leasing. Most oftentimes, 99% of the time, those type of rules are not going to be valid. This is circumventing what's required to be contained in a declaration. So again, I mention this because I want you to know the law here, and I want you to be able to at least go to your client's declaration of condominium and sort of take a review to see what type of leasing and other transfer restrictions are actually in that document, as opposed to maybe these rules. Maybe they really might not be valid rules. Additionally, these transfer and screening requirements that I speak of, they need to be pretty specific. They can't be vague, because the associations will not be able to enforce vague rules. So when you're dealing with transfers, you need to know what type of transfer is it? Is it a sale? Is it a non-sale? Is it some other special transfers? Some associations can't really deal with things that don't fit the box well. So if you have a transfer for, let's say, to a current owner in the condo, or an owner's family member, or some other special circumstance, there might be some type of exception for this that you might want to be on the lookout for. So again, I'm mentioning this because these things need to be specific, and they're not always the same. It's not a one size fits box for these transfer restrictions in all of these properties. You deal with a lot of properties out there. I deal with a lot of associations. So I know, and you know, that everything is not the same across the board here, and you need to be cognizant about that. Specific here, and very specific to condo and well protected in condos, are leasing restrictions. Again, the authority to have leasing restrictions are generally going to be in the declaration. If you don't see leasing approval or screening authority in your declaration, and you have some rules or application that purports to have very stringent requirements, this is something that you want to really maybe dig into to see if this is really binding on your client or this association. Even more so in a condo association, if you're representing an owner who wants to lease, your owner might be exempt or grandfathered into certain leasing restrictions that might otherwise be valid. The law on condo leasing was changed a long time ago to provide that an amendment to the declaration prohibiting unit owners from renting, altering the duration of the rental term, or specifying or limiting the number of times owners can rent only apply to owners that consented to that amendment, or to owners who purchased after that amendment became effective, which means it was recorded in the public records. So if you have a client who's owned a condo for quite a long time, the association subsequently amended the declaration to provide for all these detailed leasing restrictions, your client might not be subject to those leasing restrictions because maybe they didn't vote for them. So that's a pretty good area to think about in terms of leasing and where you can maybe get around this, because the associations are the party that have to show that your client did consent to it. So the presumption is that unless the association can show that your client is subject to these leasing restrictions, you might have a good workaround there. So what are some of the limitations sort of on this approval authority? Just to clarify, there's rights of approval and disapproval, which mean really the right to approve the transfer or disapprove based on certain criteria that the either in the declaration itself or in rules and regulations adopted by the board. Of course, I've already mentioned that restrictions in the declaration are much more enforceable. So if you have the criteria in the declaration, and we'll talk about this later in the presentation, it's going to be better. Criteria that the board adopts from time to time in board policies or rules is likely going to be enforceable, but it could be attacked more easily. Then you have the second bullet point here is the right of first refusal or substitution of purchaser. This is different than a straight right of approval. This is where your client's transfer seller here might be disapproved, but in order to disapprove it, the association actually has to buy the unit or provide a substitute purchaser, typically on the same terms and conditions as proposed by the seller if it's an arm's length transfer. Be careful here because some documents actually require that the seller make a specific demand for the substitute in the event it's disapproved. So this could be a pitfall area. If you don't make that demand, that could be something of a concern. Applications, they're going to request a lot of information. We all know that. And frankly, the associations can get away with that. They can get away with asking for quite a lot of personal information, bank account information, financial information, if their criteria is specific. It's always better to be specific. This is an area that gets pretty hairy sometimes, but I will say that in my opinion, the associations, if authorized, can request a lot of this stuff, background, where you live, obviously, financial references, credit report, background report, character references. We do see people object from time to time regarding access to, bank account balances or tax return information, but that's an area that I think is defensible for associations if their authority is specific here. The timeline is important to keep in mind from your perspective that the associations have usually quite a lot of time to review transfers. The specific time periods are going to be in the documents, and these are what the associations must comply with. If they don't get back to you within X number of days as specified in the documents, and usually the transfer is going to be deemed approved. These are all different. There's once again no one size fits all here. I typically see anything from 15 to 30 days, but that is not triggered a lot of the time until you've completed the application process and you give the last piece of paper to the association. So it may seem that it's rather quick, or it should be rather quick, if you have all of your ducks in a row and you have everything ready to be submitted. If you are not having all of your ducks in a row and it's taking some time, it could feel that it takes a long time. That's true. I wanted to mention that in Broward and Miami-Dade, there are local ordinances that require associations to provide for approvals within shorter periods of time, here 15 days. If you have an incomplete application, they must get back to you and let you know what else you need to submit in order to proceed with that. And they have to take, and they can't take more than 45 days to approve or reject the transfer. So in Miami-Dade and Broward, you do have more certainty as to these time frames for approval.
So now that Alice told you how to go do everything, I'm here to tell you how I'm going to come take all your money. So transfers and other charges. So you have to understand the charges that are out there. You have obviously the application fee, transfer fee, the notorious estoppel fee, an FAQ charge. There's other fees that tend to show up on all these, whether it be elevator access fees, account setup fees. Are there fines on the property? There's attorney's fees that may be incurred, and there may be security deposits. So there's a host of charges. So what are all these fees, because that's how I think everybody views this, is it's just money going out to the association left and right. Well, first and foremost, we have the transfer fee. And it's explicitly there. No charge shall be made in connection with the sale, mortgage, lease, sublease, transfer, unless, as Allison noted, it has to be provided for in the declaration, articles, or bylaws. Again, that authority has to be provided. It's not this inherent power. And further, an application fee cannot exceed $100 per applicant, husband or wife, parent, dependent child, with one applicant. And if the lease or sublease is a renewal, we're not charging an application fee. I will note that right now, pending before the legislature for what I feel like is the third year, is Senate Bill 630, which is designed to increase that $100 to $150. And I think I can hear the collective groan of about 139 participants on this call saying, oh, it went up. So that's the long and short of that's that special magical transfer fee. So that's its own unique, but there's more than that. There's the infamous estoppel fee. Then, so background on this, I was there when we had the last round of what I like to call the estoppel wars in that 2014-15 period, where you were getting estoppel fees of $700, $900, $1,000. So I'm intimately familiar with this statute because in some ways I actually helped have to rewrite this. So the statute is specific for condo, 718.116.8, it's there. If we're going to give you an estoppel, no more of this, hey, here's your estoppel on a Friday and it's only good till Monday. And if you can't close in that period of time, you got to come back and get it. It's a 30-day validity period, 35 if I mail, and I don't think anybody uses the mail anymore to send estoppels. So I pretty much do. So what are the fees? A flat $250 fee if I'm going to deliver an estoppel within 10 days from receipt of the request, and if the account does not owe any delinquent amounts to the association. So right off the bat, there's a $250 estoppel fee. I may charge an extra $100 fee for delivery within 3 business days of receipt if you request expedited delivery. This isn't an automatic. You have to request the expedited delivery. I just don't get to tack on a $100 surcharge. And if there's delinquent amounts owed to the association, then I get to charge an extra $150. So as you can see, these numbers start to creep up exponentially, and added into this, even though it's not an estoppel fee, is there may be attorney's fees coming if the account is delinquent. One thing to remember in all of this, and this was a huge issue several years ago and still seems to be despite our best effort, estoppel fees are refundable. I can't issue you an estoppel that says, here it is, here's all the money you owe me, and by the way, you can't get your money back if it doesn't close. The statute is specific on that the estoppel fee is refundable. I can't make you sign away that right by saying, by requesting this estoppel, you waive your right to reclaim a refund. You're going to have to request the refund in writing within 30 days from the date from which the closing was prepared, and you're going to have to provide me some sort of reasonable documentation that the closing didn't go forward or the transaction fell through. So keep in mind, it's on you to request the estoppel fee. So if the closing falls, that clock starts ticking. And don't just send an email. A lot of people like to just think, hey, look, I sent an email to the association, said closing fell through, need a refund. That doesn't cut it. You have to give me some reasonable documentation as well. Unfortunately, there is no case law on what is reasonable documentation. And a lot of times you may not have reasonable documentation, but I think you can get it in conjunction with the closing agent, the necessary documents to come back and say, here it didn't go through, and at which point then you get your estoppel fee back and it becomes a charge against the unit owner for that was being sold. So what is the estoppel supposed to have? And this is a bane of my life when I see these. I see all these estoppels come flying out that literally just say, here's the money owed. The statute was specifically designed to create a form within it that includes a plethora of information. It's the date that it's issued. It's got the name of the owner, the unit designation, and the address. Is there a parking or garage space that comes with it? If it's turned over for collection, I've got the account, it has my contact information. What's the fee being charged? Who requested? There's a host of information on the assessments, the amount of the assessment, when it's paid through, when the next assessment is coming due. I've got to itemize out all the monies owed. Are there transfer fees or other fees that are due? Are there open violations of the rules? Is there a board approval required for the sale, and has it been obtained? There's their right of first refusal, and there's other information. So when you get that estoppel from the association, make sure you're getting all of this information because it's supposed to be provided to you as a matter of law, not just simply as saying there's $2,000 owed on this account. The next assessment is due April 1st. That's not what the estoppel requires. So get what you pay for. So the frequently asked question and frequently asked question fees, another adventurous item and another fee that comes out of pocket. So the association has to maintain the FAQ as part of its official record, mandated by law. I may charge you $150 for that FAQ. So in addition to all those estoppel fees, here's another little fee creeping in. If there's any additional information that's requested from the association that's not required by law, it may also be charged a $150 fee plus reasonable cost and reasonable attorney's fees incurred in responding. A lot of times where I see this one pop up is when people want details on any pending litigation the association is involved with, because the lender needs it in order to clear its closing requirements. Note that the association must maintain the frequently asked question sheet, a number of copies of the governing documents and financial statements on site, and charge actual cost of copies. However, the unit owner, the member, or representative, i.e. you guys that are watching this, can make copies with a smartphone, portable scanner, any other thing, and we can't charge for the use of that device. I will tell you though, if you're going to go make copies of all this, it is going to be pretty voluminous. Your standard declaration with exhibits could be 150, 200 pages. And by the time you start putting in the financials, you may be making copies of something close to 300 pages total. So be aware of that. And now for the infamous other fees. These are the ones that I hear more complaints about than anything. These are fees that are not provided for specifically in the statute and instead are addressed in a contract between the association and the management company, i.e. what are we charging for all these other ancillary charges? When a new owner comes in, there's going to be a $350 account setup fee. That's one of the most common ones I see. The fees are set by the contract and they're passed on to the applicant. So a lot of times when people complain and say the estoppel fee is $1,500, I'll look at it and, well, the estoppel fee is correct by statute. It's all these other little ancillary charges that get added in. Note, there's no agency that regulates any of these fees provided for in the management contract. These are strictly fees provided for in the contract between the association and the management company, and they, quote unquote, are pass-through fees. And if you want to object, really, there's no governmental agency you can go to. Maybe there's some local consumer protection that might get in, but odds are you're not going to get an answer within the time period you need to get your closing requirements cleared. So as we talked about, account setup fee. Another one is the move-in, move-out fee. There's an elevator usage fee. I see that one a lot. There's condo dock fees that are separately provided for by some management companies. And oftentimes they'll also just charge a fee because it's a refinance rather than a sale or closing. Do note though that the Florida statute 718.111.4 does provide for an exclusive use fee. So if you're going to have an exclusive use of the common elements, i.e. the elevator, then arguably the association has the legal right pursuant to the Condo Act to charge that fee. Also note that a lot of these documents that you may be getting charged for are supposed to be covered by the contract. You know, the FAR Bar condo writer requires a certain number of documents to be provided, 3 days prior to the contract of delivery with a 3-day right of rescission. You can check the box on there and say, I don't want the documents, but you're going to want these documents. As Allison noted, all these powers are in these documents. A lot of the information you're looking for are in these documents. And so don't have your default practice being to check the box that says, I don't want these documents to be provided by the seller. They exist for a reason. It is consumer protection oriented so that the buyer knows what they're getting into. You know what the authority of the association is. You know if they have that broad sweeping authority that we like to claim, or whether we have no authority at all. So make sure you get those documents and that you thoroughly review them. That's what that 3-day right is there for. It is a consumer protection statute that somehow, despite all that's going on, still remains and hasn't been voided out. What other fees can we have? We love to charge security deposits to you guys. Again, we need to have the authority in the declaration or bylaws. Then we can require that prospective lessee to place a security deposit in an amount not to exceed 1 month's rent into an escrow maintained by the association, so that in the event the tenant damages the common elements or association property, we have a source of money in which to claim. Everything gets handled as a claim on a deposit under Chapter 83 of the Florida statutes. But also keep in mind that if an association has this authority, this is separate and apart from the security deposits required by the landlord. So for those of you that handle leasing transactions on a regular basis, you may not only have a landlord who wants a security deposit, wants a first and last month's rent, but then you may also have the association requiring a security deposit of a month's rent as well. So in theory, you may have 4 separate deposits floating around on that singular lease. So with all these fees in existence, what are the future of the fees? Well, as we start to hear, and as we know, there's grumblings in Tallahassee with the ongoing estoppel fees and what exactly is covered in the estoppel fee and these ancillary fees. We expect the legislative battle to come back again to try and tackle this issue further. It's known, it's been discussed about openly up there. We know the estoppels are coming. So as I jokingly refer to it, it's Estoppel Wars Part 2. However, it's probably not going to get until the 2023 legislative session. It was possibly this year, but didn't. Next year doesn't look good as well, since it's going to be a re-election year. Also note that you're seeing now class action litigation against association for charging fees in excess of these transfer fees amount. So that's one of the prominent things we're finding, is that if the legislature's not going to fix it, that people will bring a class action on behalf of whether it's all tenants, all purchasers, against the association to challenge for those fees. Also keep in mind that there is always a difference between a fee, an assessment, and a deposit. But note, just because I call it one of those may not mean that it is. So Allison, we've gone through all that. We've got the documents, they pay the fees, and despite all that, we don't want to approve. So what are we doing now? Muted.
Back to approval, disapproval issues here. We're now to the point where you believe you've submitted everything for your transfer and the association has it. You know, what did they look at? What can they look at? How does this all go down? As I already mentioned quite a few times, the approval, disapproval should be based on written criteria. And this is not just criteria that the president comes up with that day or that week or that month and it's not written down. That's not going to cut it for associations. So you need to see this, particularly in terms of transfers of title, in writing, written down for transfers of title, most oftentimes in the declaration rather specifically, and if not in the declaration, in written rules that somebody can provide to you. With respect to leases, there's a little bit more, it's a little more of a gray area, I would say. In my opinion, the specific criteria for lease disapproval probably doesn't have to be in the declaration of condominium, but it should be written down. It can't just be made up. That's arbitrary and it's not going to work for these associations that you're dealing with. Some of the criteria that we see time after time, and I write these amendments, I write declaration amendments and rules criteria, so I know exactly what these things should say and what they shouldn't say. Again, it should be rather specific. There's always going to be some amount of subjectivity in terms of a board reviewing transfers and the background of proposed transferees, but it should be somewhat objective in terms of what is written down on that page. So some of the standards we typically see from associations deal with financial irresponsibility. Does your client, the buyer, or frankly the tenant, have the wherewithal to pay assessments and keep afloat in the building and have equity in the unit to assure that it can pay assessments? Tenants are a little bit different. We'll talk about that. Has this person that submitted for approval, the applicant, been in the condo and already violated the rules? Maybe they were a tenant and now they're trying to buy, but when they were a tenant, they were a nightmare and they had a lot of rule violations. We see that as part of the criteria, that they just weren't very nice or that they were disruptive. So I think that's legitimate. If they've already proved to be disruptive, why should the association have to continue allowing it? But most oftentimes, the one that I see as the pitfall issue is going to be some type of criminal background, whether it's a felony or a misdemeanor, that this applicant has some type of issue where the association feels it's a safety concern to allow them, or they're just not desirable to occupy the condo. So there are other criteria that could be used, but these are probably the more frequent ones I see, and the financial irresponsibility and the criminal background seem to come up all of the time. There are a lot of considerations that need to be made by the boards in using the criteria. We'll get to some of the other details on this. There's discrimination, there's disparate impact discrimination, but sometimes it can be so simple as, pets, that's a criteria. One of the things that we didn't talk about was the association can disapprove for what we know as, in my world, is failure to facially qualify as a member. That basically your applicant, your buyer, has a pet or a vehicle that just does not comply with the current restrictions of the association. If the declaration says 1 pet and your client has 3 pets, that's a problem. The association can disapprove and is not going to probably have to provide any substitute, anything, as long as it notifies you in a timely manner in accordance with all of the timeframes set forth in the documents. This leads us down a complete other path of the assistance animal issue, which we see a lot of. If you have a condo that says 1 pet and you have 3, all of a sudden now we see that 2 of these pets are emotional support animals. So that is a whole nother course, but that is something that we do see quite a lot. A lot of the restrictions that the associations use, the criteria, can bring up fair housing discrimination issues. If they're using the criminal background or the financials to overtly discriminate against certain classes, that's a problem. The associations can't do that. Your prospective buyer or your prospective tenant has claims against the association if the association is jerking them around and it's overtly discriminatory. Also, the associations cannot use the criteria and essentially have it result in disparate impact discrimination, where it's not overtly discriminatory, but the way that it's all working out is discriminatory on a certain class. And we do see allegations of that with respect to credit score issues and criminal background of applicants. Realize that in addition to the protected classes under federal law and state law, we have different and additional protected classes in various counties. And this slide's pretty interesting. It notes some of the extra protections provided in Broward and Miami-Dade. Palm Beach has some as well. But as you sort of go up the coast, you drop off in terms of extra protections up in Martin and St. Lucie County. Those are basically at the federal level of protection. Very important to mention that prior arrests of these applicants should not be used by associations. Our clients, my clients, typically get a little overzealous in reviewing the applications and the backgrounds, and they don't know what they're reading a lot of the time, which is, it's a little scary sometimes, that they believe that if somebody was arrested or had adjudication withheld for a certain criminal issue, that means that they've been convicted and that they can keep them out. So these things have to be very carefully reviewed by the associations, and sometimes you'll see and you'll find that they're not reviewing them properly, and it needs to be brought to their attention when they've gone on the wrong path and it needs to be objected to. So prior arrests, frankly, should never be used in consideration for applicants by associations. They will see them on the reports and it will be viewable. Prior convictions of felonies are really the only crimes that should be reviewed by associations according to HUD standards from a couple years ago. If you have to really think about these things, and it does have some subjectivity to it for boards, when the conviction occurred, what the underlying contact or conduct was, when this incident actually occurred. So when I write the criteria for associations, we take all of this into consideration, and sometimes we'll have like a 10-year look back for certain types of crimes or a shorter look back for crimes that aren't as concerning. Any type of drug distribution crimes are fair game for disapproval, sex offender status, violence to persons, severe violence to or destruction of property. So I think a lot of those are what we'll see in my detailed criteria that I write. Again, you really need to look at the nature, severity, and how long ago this occurred. If you have an applicant who had a DUI 10 years ago that didn't result in any injuries or damage to property, that's probably not something that in and of itself an association would be able to use to disapprove a transfer. We hear about the credit score all the time for associations. As I mentioned, it was one of the more typically used criteria to base approvals and disapprovals upon. In my opinion, credit score alone should not be used to disapprove a transfer, but it could be used as a factor. It is one factor to use along with a credit report, history of evictions, foreclosures, and it's one factor. When I advise associations to use this factor, I think that you need to be somewhat flexible in terms of moving from year to year. So if an association has a specific credit score for 2020, I sometimes say that let's look at that on a yearly basis and assure that it's actually reasonable as we continue with time. So these are not things that should be changed by boards daily, weekly, monthly, as I mentioned before, but it does behoove an association board to look at these things from time to time and make sure that they're still up to the standard of the day, 2021 at this point. So I hear all the time that financial responsibility should not matter for a proposed tenant. Who cares whether a tenant has a bad credit score or a prior history of delinquencies, write-offs, bad credit report. And I can understand what that approach to the situation, but on the other hand, my clients need to assure that the condos are up to standard, run well, everyone's reasonably happy, and bills can be paid. So if an owner is delinquent in the payment of assessments to the association, then the association can make a direct demand to the tenant to pay rent to the association. So I think that really in and of itself gives the associations a lot of defense to requiring tenants to have a decent credit score, credit, financial responsibility, because if the associations are dependent on getting rent from the tenant to ensure that assessments are paid, I think that's pretty important and gives them a pretty good leg to stand on there. But it is an area that we hear objections to rather frequently.
Actually, Allison, if I can interrupt you for a moment, the Q&A is actually already full of questions related to this credit score issue.
Okay,
So
good. We'll talk about that more, I guess.
If it does come up, we're looking for what can they do in this situation. So we can cover it when we finish this, but I wanted to let you know this is definitely something we're going to dive deep into.
All right, very good. I'll be thinking about that. Well, Sean, you can jump in here regarding enforcement and what happens when all of this becomes a problem and boards are acting in a manner maybe that they shouldn't, or things are going a little off the rails. What do you say?
Yeah, that's probably one of this mess is, Allison's gotten involved, taking care of it, and then it's blown up. And so now it's time for me to come in. As I always say, I'm not a good cop or a bad cop. I'm a different kind of cop. So what am I going to do? I have a host of options if it doesn't get approved. Whether, you just decide to say, nah, forget you. I'm still going to do this transaction. We're going to close. You've got a closing agent who's willing to overlook the approval, and you're just going to run it through. Sometimes it may be as simple as say, what, you got through, you didn't turn in the application, you got around it. Let's give you a chance just to cure it. I'm in a generous mood today, and I'm going to allow you to fix this problem. Hopefully it's one that's a minor, such as you just didn't turn in certain information, and not something that you went and run around the screening process and you literally have brought a felon in here who would never qualify. If you've got this person in there, Maybe I'm going to tow and immobilize the vehicle. I used to always joke with my clients that if you're unsure of who's renting a unit or leasing it, once you tow a vehicle, you will know exactly who's in that property. If it's an unapproved occupant, I may seek an eviction action or an ejectment action, depending upon the relationship that I got there. So I may just wade into this and decide to just get rid of the problem completely. If you're unapproved, I contain the right to have trespass action brought against you for certain portions of the property. I can seek an injunction against you and the owner, whether it's a tenant issue. So I can come in and start asking the court to enjoin you from residing in the property. I may look to unwind the entire transaction. I've actually had to bring those cases, and fortunately they've settled, so we've never had to completely unwind it. But if you go through and try and circumvent the process, and this person never would have qualified for any type of membership in the community, and you've closed, and think about that, you've closed, you've funded the loan transaction, we paid off another loan, and you didn't get this approval, and I come in, I'm going to seek to unwind all of that and undo all of these loan transactions. And that's not going to look good for anybody on that end of the equation. I also have the ability to fine and suspend use rights depending upon what it is. So I've got a host of tools, and the last thing you want to do is let me play in my toolbox. You'd much rather deal with Allison and the mundane run-of-the-mill process than hand it over to me and just say, you know what, I'm going to come rain death and destruction on you. I have the ability to get attorney's fees for this type of stuff, whether it's injunctive relief, enforcing the documents. There may be additional fees provided for in the documents themselves, and I'm bringing litigation beyond what the statute requires. Now, one item that I think you should note with here is, there's no standing generally for prospective owners and tenants to enforce the governing documents, but you have other discriminatory housing practices or claims. But note, there's this weird issue in Florida, and it triggers on the doctrine of equitable conversion. So what is that? Well, this case sums it up. If you have a contract to convey legal title upon the payment of the purchase price, then the buyer gets an equitable interest. So in a roundabout way, the buyer's the beneficial owner, while the seller maintains what we like to call naked title, i.e. we're all set to close. This is in any standard real estate contract. The buyer becomes equitable owner upon execution of the contract. So all of you are sitting in this call and going, great, my buyer has standing. And I go, time out, sorry. In Florida, the rights flow to the record owner. So the statute is specific, the owner of record. So just because you've signed that contract and you have the beneficial owner, doesn't mean you're going to have standing to come after the association. It's going to be the seller, and the buyer's claims are very limited if anything goes wrong on their mind. So where does that leave us? Some final thoughts here before we get into what looks to be a very full question and answer. What are our final thoughts? Generally, we're willing to help the transfer go forward. It seems we've given you this thing, and as one of my colleagues jokingly referred to me after I gave one of these presentations, I was the Dark Lord of Condo, there to destroy everything. Generally not, though. We want the transfers to go forward. The sale of units increases the value of other units, and it may be somebody we just want to get rid of in the community. But also think about this. Be considerate of time considerations when you're dealing with the association. Once you sign that contract, a lot of times there's a certain time period in which to go get inspections to get out of the contract. Treat the association as you would one of those things. Don't wait until 2 to 3 days prior to closing and then come to the association, go, here's my application and everything, because some of these documents, as Allison noted, have a lengthy approval process. And I've seen some that have 90 days. And so you may be ready to close 3 days from now into the contract and you've not come to me. And I suddenly have a 90-day window in which to hijack your closing and have it extended. Understand what the condo association's approval process is, what information is going to be required, and what authority we have. That's where those documents that come with that condo writer come in handy. Don't just check, no, I don't want these. You want these documents. You want to understand what you're getting. And finally, remain professional. If you call up myself, you call us, and you start screaming at us, yelling at us, saying, do you understand I've got this closing and it's in 3 days? And you start calling us all kinds of names and making all kinds of threats. I may tell my clients this is what's going on, and generally we're just going to soft pedal that issue because, bottom line is if you're not nice to us, then what's our incentive to help? So think about that. Remain professional and be considerate of the time. Think about those as you move forward with this. And with that, we are at questions. So without further ado, let's let it rip.
All right, Jessica and I are ready. Here we go. First question. Lisa Stewart asks, major concern with rentals. Landlord approved the tenant, however, the board requires the tenants to have a specific credit score. What rights does the association have to require this? But more specifically, where would it need to be stated in the condo docs that this, is it a number? Is it just a statement? Where do they get the power to require this?
So this was a tenant who needed a specific credit score. And as I've mentioned several times here, the huge takeaway is approval of tenants is not inherent. It has to be authorized by the declaration. If your declaration of condominium says that the approval of tenants is not required, just keep us updated as to occupancy, there's none of this stuff. So that's a threshold matter. The declaration of condominium must provide for these approval authorities. Once you have that, then we're down to what is the criteria. I mentioned for a tenant and, frankly, for a transfer of sale by sale, the number, the credit score is probably not going to be within the declaration of condominium because that doesn't make sense to have a static number in a document that is difficult to change. So the declaration is probably just going to say the criteria is financial responsibility. So in such case, it would be my preference and my advice for my association client to have a separate document that supplements the declaration, some rule, some written policy that says this is how we evaluate financial responsibility. And the credit score can be one of the factors, right? Sometimes people have been in a bad situation and their credit score is not so great as they thought it should be, but they have a lot of income coming in, or there's other factors that they could show that they have the financial wherewithal to pay assessments or pay rent. In that case, if you have a situation where you're stopped up because they're, insisting on the number, I would try to compile a letter, a document to show the other factors that they do have that can overcome this credit score. Practically speaking, I think that's the way that you would need to handle it. To show, look, when you look at my complete picture, I am responsible. I happen to have a low credit score because of X, Y, and Z, but this other stuff overcomes that, and I think I should be approved.
And I would add to that, if you're a realtor who represents landlords, understand that your owner has the ability to get records from the association. And so I think in the course of dealing with your client, you're going to want them to get those documents from the association that are, required to be maintained, that we discussed in the presentation, so that they're handy and that you keep that sort of a running tab on that. So that way you always know what the association standards are versus just blithely going forward and suddenly running into this roadblock. If you know ahead of time, because you have the documents, this is our authority and this is what we require, you're going to save yourself a lot of headaches.
All right, thank you very much.
Jessica.
Our next question is coming from Scott Karp. Is it legal to ask for tax returns?
Well, there's a lot of difference of opinion on this in terms of condo lawyering, I suppose. It all goes back to what I keep harping on about authorities. So first of all, you would have to have the authority to approve this thing. You would have to have criteria concerning financial responsibility, the authority to require the tax return. I would want to see specifically mentioned in the criteria. But I think if all of that lines up, and for a buyer, not really a tenant, I don't know how, I think, I'm not sure it would be as relevant, but for a buyer, my clients ask for it, and I think it's enforceable if all of the authorities do line up. It's one of the factors that I think can be used. I know there's a case, a circuit court case out there from over on your side, Sean, that deemed the tax returns unreasonable, but that's just one case and it's not binding. And frankly, all of the associations down my coast ask for this, and I think it's valid.
And if the court may have held it's unreasonable, but as Allison noted in her part of the presentation, rules have to be reasonable, but when it comes to restrictions that are in the declaration, the law allows them to be a little bit unreasonable. So if you fret and say, the declaration says tax returns because somebody put it there, and you say that's unreasonable, the law generally allows the declaration to be unreasonable. So understand that just because you're dealing with a condo association, that not everything's inherently fair and reasonable.
And we don't really want to ask for this just to be nosy and find out about things. It's really to assure payment of assessments after the bubble, 2008, 2000, that time period, the associations got very sensitive and they had a lot of units that, were left unpaid, and they want to assure that whoever comes in is really able to deal with these payments, and some of them are quite large.
So along the same lines, I just wanted to mention, because so many questions are related to this, there's nothing in law that addresses specifically a credit score. There's nothing at HUD that addresses a fair housing. And I take this from my experience in speaking with HUD. They are really silent on this issue of minimum credit score. And a lot of the associations will say, it's based on a financial decision, and then they kind of have this leeway on the documents that they're requesting. And so is this something, in your experience of being a Reptile member with the Florida Bar, is this something you guys are discussing or looking at potentially moving forward, having some kind of clarification? Because I think you're hearing it loud and clear from our members and from your members about, a lot of conversation built around this credit worthiness topic.
Well, it brings up the whole disparate impact discrimination issue. There's nothing in the law specific about credit scores or specific about numbers, but just in, the same as everybody deals with in real estate transactions, you can't impose discriminatory conditions. And the argument is that the credit score disparately impacts protected classes, and it could be problematic. It's just not that black and white, though. So it depends on so many factors, the demographics of the community and what's actually happening over there. So as to potential changes, Sean, I don't know if you've heard anything. I frankly have not.
No, it's not on the horizon legislatively, and candidly doing enough of this legislation. That'd be really tough to draft something that specifically gets into there. I think you're seeing local governments at least try and step in some fashion to this issue in a way, with income discrimination being a protected class. And this whole Section 8 issue is actually a big deal up here where I am in Hillsborough, where the county just literally within the past 2 weeks did a tenant bill of rights that included you could not discriminate based upon receipt of Section 8 housing income. So that's where I think you're starting to see is a realization that you're not going to get anything from the federal level, and definitely not at the state level. So you're getting it at a more local level. So for those of you that have multi-county practice, understand, and like Allison made the comment, the further you go up the coast, the more it changes. So understand that, what works in Broward and Miami-Dade is not going to come work over here in Hillsborough or Pinellas.
And that's true. I believe in Broward, and I believe Miami, that income is a specific protected class. There's a slide on that we can look back at, but that's something to think about.
Yes, also, we had a question about
speaking,
Section
though,
8.
Practically speaking, I think that showing that you have other responsible factors is the way to deal with it, practically speaking.
My question always comes at the end of the day of, if I get sued, can I explain this to a judge in a reasonable way that doesn't make me look draconian?
Thank you. And I actually have a question from Walter along those lines. Walter recently had a condo board deny a buyer because of income. Mortgage company approved the buyer for an 80% loan to value mortgage. What options, if any, do we as the realtors in this transaction have to challenge that decision?
That's difficult, because Sean mentioned, and I think it's worth harping on and worth really emphasizing, that the buyer doesn't have standing to challenge the approval process or the criteria other than as discriminatory. So if you want to challenge the process as unreasonable covenants or unreasonable rule, that really lies with the seller. You can team up and try to do it together, but it's not going to be quick.
No, it's not going to move. I mean, and you would want to also make sure, as Allison noted, that they did have this authority to disapprove, period, because too many associations out there just like to think that they have it, that as a matter of law, they have this power when they don't. So, the first thing you're going to want to do is, you've gotten those documents because you got them with the writer, go through and double check and make sure that's there. And if the authority is there, then, well, you're kind of between a rock and a hard place. I will say that probably one place if I got sued with my client that I don't want to be is walking into a court and having the judge go, well, wait a minute. They can qualify for a federally backed loan, but they can't qualify for your community. I know many a judge that would have that as the first conversation, and I'm already going to be on the defensive, and I may be able to justify it all, but I already know where this is going.
And actually, we have a question kind of similar. Can a condo restrict purchase or rentals to US citizens and permanent residents only?
I would have to say no. I've had this question before. I think that that's national origin discrimination. I think that's a horrible idea. I've had clients ask this before, so the issue is out there. People just must not realize. But no, that's a pretty easy one for us lawyers that I would tell my client absolutely not.
And that's one of those where the prospective buyer tenant gets standing, because that's the outright discrimination claim that they can make. And, along those lines, I've had several cases up here where the criminal history issue, where it's the arrest, and just advertising that you're going to say no arrest immediately triggers a fair housing violation. And so in the past 6 months, I've had the pleasure of being in 2 federal lawsuits on that exact topic.
But
And I have another.
Oh, sorry. Go ahead. Go ahead, Jessica.
Oh, no, if you have something to add, please do.
I was just going to mention off Sean's point about the whole approval aspect. I've been harping on it. If you see that, there's something just wrong with this issue, that you're having a lot of criteria or documents that they're requesting, and that there's just no approval authority in the documents, call the association out on it, write them a letter and just say your declaration does not provide for approval authority. See Article 4, Section 2, where it specifically says you don't have authority and that you only get the names and contact of the people, the tenant maybe that we put into the unit. So that's pretty powerful. A lot of the times associations just think that they're the gorilla and that they're going to be able to strong arm whether they have the authority or not. So that could be rather effective to just sort of call them out on it as a first attempt.
Or in doubt, retain Allison or myself. We'd
Of
love
course,
to handle these cases.
And
We're
Jessica, before I ask the next question, because this is something that we get a lot of complaints about, getting access to those documents. And so Sean mentioned that, you do have the right as the seller's representative to go in and make those electronic copies. And I know you said they can be voluminous, but we often I can't get those documents. I can't get a phone call on the other line. I don't have an email address and that's one of the areas that we've been looking at trying to get publication more. And then you also mentioned the website, if you just want to readdress that, 150 units or more, and then Jessica will hit the next question.
Yeah, I mean, it's an ongoing issue, and even small associations, a lot of times those documents are posted on the website. So they're accessible. It may be cumbersome. And I know people hate to say I have to get a lawyer involved, but often if you're getting somebody like myself or Allison involved that knows how to speak to the association and their counsel and walk through it, we excel at cutting through the red tape and getting you to that point faster versus, you send a letter and then it goes to the association, then it passes on to the manager, who then passes on to the attorney, and then 2 weeks have gone by and you're sitting here watching your closing deadline creeping up and your inspection period's coming to a close and you're debating whether you need an addendum to start extending things.
But I do realize it can be difficult to get in contact and to get documents. The websites are helpful. Sometimes, they're password protected, so only the seller can access them. So if you're the buyer rep, you need to work hand in hand with the seller to ask the seller to get on the website, log in, pull up the stuff, save it in Dropbox, send it over. So I think working together is going to be helpful there. The law only requires condos with 150 units or more to have websites, but a lot of the smaller ones have websites anyway, or their management company might have a website. So if you can figure out who the management company is, it might be able to get you there. But I do realize it's difficult, particularly during COVID. It's been difficult for records exchanges when there are no websites, when they're just hard copies in a management company office. They may have been closed for months due to COVID and social distancing. I've had a lot of practical issues myself with setting up records inspections. So we are thinking about this as members of Reptile and condo attorneys. and to try to get into a new world where, you know, we have better technology options that help out, you know, really a lot of parties here. So we are thinking about that for the future.
Yeah, we do a digitization project that Allison's sort of taken the lead on, of trying to have the records become more digitized and user-friendly so that you're not having to jump through all these hoops, and it becomes easier to get a hold of everything in any community. So it is something legislatively we're at least looking at.
You can pop onto the public records, official records site in the county that you're located, but you know, that's not easy and you might miss something if you don't know how to use that. So I like mentioning that, but it's not going to eliminate the need to get the official documents probably from the association or a title company to make sure you have a complete set. Because I keep talking about these authorities. You might have the documents from 1982 and they've redone their documents in 1995 and 97 and 2001, and you don't have any of the amendments. So if you're relying on just the original docs, that's not going to help you. And you know this.
Thank you both. So I was going to ask a question and then it disappeared. So, but my question was, and it was from, goodness, his name is now escaping me, but it was along the lines of having foreign nationals who do not have any kind of credit score or background. And how do you deal with those kinds of requirements when they literally don't have credit because they're coming to our country from another country?
Sean, I mean, I deal with this not all the time, but it comes up quite frequently that you don't have a social security number or you don't have credit. And the clients just want to, a lot of the times, you know, not all the time, I'm talking about, you know, the worst case here, that they just want to not deal with it or just disapprove it as a matter of course. That's not correct. You must have alternatives, procedures to screen individuals that are foreign and don't have the same contact information as most people here. I mean, there are background companies that can perform background searches on these individuals. They're not as inexpensive as a typical background check, and it might cost you well in excess of that $100 transfer fee. It might be up near, you know, $300 to $500. But if you really want to get the information, you need to go that route. You can't not use it as an excuse to just disapprove.
And I think it also goes to what we were talking about of, once you sign that contract and everything's ready and you're starting to go forth your inspections, put the association up there in that category as well. Understand what are these requirements that you've got to go through with the association, or do you have a unique issue like a foreign national where screening authority exists that you want to tackle up early on in the process versus dropping it on us 4 days prior to closing and saying, oh, by the way, this person's from Venezuela. And suddenly we're like, okay, this is going to be an adventure. And now the closing's been kicked out and there's all kinds of headaches. So be proactive and think about that. The association should be a tantamount to one of the first things that you deal with once you sign that contract.
And there might be some alternative information that we might need to obtain from these individuals. And, you know, that raises issues. Why are we treating these people different? But it is inherently different. And I think associations can be justified in asking for alternative information, somewhat similar to what I mentioned about the credit score. If there's a poor credit score, but you have other documentation you can provide to overcome that, that's great. Similar here, if the association's asking for X, but your client doesn't have X, I would just try to offer Y. Just try to be proactive in making this easy for the association and trying to comply with the requests. And I know they can seem unreasonable at times, but we all want, you know, the same thing for the transaction to move forward. What else we have?
So many, so many. Okay, why are associations permitted to take more than 30 days to process an application? Typically, a sales contract provides a closing date of 30 to 45 days from the effective date, which then contradicts with the time frame that it's needed to close.
We hear this all the time. I mean, I'll just lead off by saying, you know, you have to go back to what's in the Declaration of Condominium here. If the deadline is 30 days, what is that running from? It's typically not running from the simple furnishing of an application. It's usually running from when the application is complete that the board has the 30 days. Again, this is not one size. You have to look to your specific document, but they are going to be different most times, and they're not going to coincide with your closing date or your timeframes and your contract. Sean, we talk about this all the time. What are your thoughts?
No, it's back to that diligence concept at the beginning of understanding what you're dealing with up front. I understand, having done a ton of real estate transactions and that type of litigation, we're familiar with, hey, look, okay, 30-day close, 45-day close. It's always, or if it's one of those that's really hot, it could be a 15-day close. But understand that the association, you may have a 15-day close down in Miami on Brickell, but that association declaration may be ancient and provide for a 60. And so you've got to be cognizant and aware of that fact. And so don't go thinking that just because you sign a contract and provide a closing date that somehow puts it on the association to change its process. We will try if we can, if we've got the information timely, to move it as fast as we can. But if you, for whatever reason, say we're going to do a 15-day close on this $2.2 million penthouse unit, and I've got a 60-day approval process, and you come to me 2 days prior to closing, I'm going to tell you up front, you're going to need to change your closing date.
They're independent tracks. That's the most simple answer, that, our timeline for approval is independent of your timeline for approval. We'll try to work with you because everyone in the association is going to be in this situation at some time. That's what I like to tell my clients, that, listen, we need to help facilitate these transfers. Everyone, including the board, is going to be in the situation at some time, but they are independent.
Awesome. And this is another good question, kind of a little bit of a vocabulary lesson, if you would, please. Carlos is asking, what is the difference between eviction and ejectment?
I see Allison's deferring that one to me.
That's a Sean question, but I will say that associations do not typically have the direct authority to evict tenants, other than for, that would have to be sort of special in their documents or in special cases, that the associations typically cannot use the eviction process. They are not a landlord, but Sean, you know more about this. I don't litigate.
So yeah, eviction generally contemplates a landlord-tenant relationship. So often to get around that, you'll have associations at the time of execution of a lease will require a lease addendum that allows the association to be an attorney, in fact, to step in to have eviction authority. Also note that on that rent demand, if it's not paid, it provides for an eviction level authority as well. Generally, ejectment comes when you don't have that direct right of eviction and you've got to bring an ejectment action. And from a litigation standpoint, it makes a tremendous difference. Eviction, we're used to, you're in and out very quickly. You've got to have the payment of the rent into the registry. And if not, boom, you're in and out and done. 7-day notice for a non-monetary violation. Where if I've got to bring the ejectment action, then I turn into a regular civil action in circuit court. And so suddenly now I've got to do a full-blown lawsuit. I've got to serve it on the person individually. They've got 20 days to file a response, and we're going to get bogged down in real traditional litigation. So that's generally the gist of it, is that the eviction deals more with a direct landlord-tenant relationship unless the association's got documents that allow it in. Otherwise, we're truly having a litigation on getting this person out via the ejectment route.
So we're getting a lot of questions about condo questionnaires, and I'm gonna actually share something for a moment, because Trey Goldman, who popped in earlier in the presentation and popped out, it's because he's in session right now and is monitoring that as well. But one of the things that we've tried to do an education campaign on is around this condo questionnaire. A lot of times they'll say, I'm trying to find out if the association has budget reserves, and they'll say, oh, just fill out a condo questionnaire. So there's usually a fee for that, about $200 or $300. And what we've tried to do, there is a statute here, if you guys would like to address it, it says each prospective purchaser who enters into a contract for the purchase of the condominium is entitled to, at seller's expense, the financial information. And if you can get that like a budget summary or an itemized budget, you can find out if they have the reserve requirements or not. And you kind of want to know that information before you're paying the $200 or $300 for the condo questionnaire, because and a lot of times they're not budgeting for the reserves, and then you're not able to qualify for FHA or for the full review for Fannie and Freddie. So I don't know if you guys have dealt with that a lot, but if you want to address some of these condo questionnaire questions.
Well, the statute that is referenced in that slide is 718.11.111. So that's the statute that provides for the annual financial report. So you're entitled to the annual financial report, which has a lot of information, but it's not necessarily a copy of the budget. The budget is 718.112. So the statute that you're relying on gets you the financials, the audit, whatever type of annual report, but technically not more than that. The seller would have to go get that for you and give you whatever the current year's budget was, whether that has reserves or not. You're looking at the last year's information under the statute right here, which is, not as helpful as it could be because you don't know what the current is.
And we've talked about this with Florida Realtors because even getting this information after you've entered into a contract is kind of too late in the game. You need to know this information in advance before you're putting money into, your 10-day inspection period or, putting out money on the transaction is the point. We really need to know if the associations have the 10% going to a reserve account or not. And so again, it's just an education process because a lot of times they're saying, we'll just pay the condo questionnaire and you'll get that information. And then I get the phone call, I've paid it 3 times and I can't find a condominium that has 10% going into reserves. So just moving forward, I know we've had conversations on this, but that's really what we're looking for, assistance. And the answer here today is ask the seller for that information so they can go to the association and pull that information for you.
I think the association is going to be more receptive to that in terms of detailed financial information. The buyer could argue that the statute allows for more, but when you're the association, whether it's right or wrong, you're hesitant to release a lot of financial information. A lot of the associations think that's confidential and members can't even get it. So I think that, just because of the practical difficulties, it could be easier for the seller to get it and then turn it over to you. Whether the statute arguably gives you more authority or not, we could debate that, but we're here to sort of get you what you need and not get into the weeds about stuff.
And a related note, if you thought that was adventurous enough, just to get, this pending legislation that would allow condos to go investing reserve funds and equities. So you're trying to qualify for the 10% and suddenly now I'm off buying and shorting GameStop.
So. Another time the condo questionnaire comes up is because we spent so much time dealing with estoppels and putting a cap on how much you can charge for an estoppel. So then you take pretty much the same issue, but on the other side, and you've got this excessive fee for condo questionnaires. Is there any cap for, like we have for estoppels, is there any cap for the condo questionnaire?
I mean, the statute has the $150 for the FAQ, but once you depending upon how I like to categorize it, we can get crafty with what we call it. And then we end up into that world where it's a fee between the association and the management company, and you're just having to deal with it as it is. So I can call it all kinds of things, shift it out of a statutory provision, and suddenly we're in an unregulated market where you got to pay whatever it is I say. I do think this is one of the items we're going to see tackled legislatively because we all got creative once estoppels got capped. We're like, okay, we're just going to go make up the revenue somewhere else.
And I'll mention that there's that other statute that if you're asking for information, documents that, an association is not really required to provide more information regarding pending litigation, you want us to do some sort of notice of termination of a notice of commencement or review some sort of affidavit of sufficient funds, all of this sort of stuff where they have to get me involved, that now you're possibly having to pay my attorney's fees for reviewing all of that, which I ask for in advance, and they can get up there. So there are a lot of fees, but there are statutes that we can rely on. A lot of my clients, the condos, don't want to charge those fees. They're all not trying to charge the fees. Some of them are of the opinion, like I said before, that everybody is going to be in this boat at some point. A lot of the larger ones that we see a lot of transfers in. So if there's a litigation report that's needed or some form that needs to be reviewed, that they'll just allow me to do that and to help facilitate the transfer. It really depends on the association. And you see that a lot as well.
All right, thank you. I'm going to shift gears a little bit here. We have a question from John Kern. Sounds like he had a experience with this. Can the association change the pet policy without a vote from the owners? And it should be recorded as an amendment. Is that correct?
Allison, you're day-to-day counsel.
Yeah, well, it depends on, certain factors. The lawyer answer, it depends. If your pet restriction is in the declaration, it says that you can have one pet up to 20 pounds. And the declaration is usually going to require membership approval to amend, right? So that's sort of stuck there in time until the membership, whatever votes needed, a majority, 2/3, 3/4 votes to change that restriction. So in the event the members never vote, that restriction remains. I do see the boards trying to change restrictions by virtue of rule amendments. And we talked about this a little. If you have a 20-pound dog restriction in your declaration, your rules can't say no dog. So we see that a lot. Another pitfall for associations, frankly, is we'll see a pet in the declaration. It'll say no pet without approval of the board. That doesn't mean no pets. If the document wanted to say no pets, it should say no pets. So if it says no pets without approval of the board, it's kind of like this criteria again. Like, what is the criteria for pets? If you have no written criteria, apparently dogs are allowed. So it gets a little complicated, but once again, rules cannot conflict with the declaration. If your declaration doesn't address pets, arguably the board could adopt a rule on it. Rules and amendments only apply prospectively. So that applies to people in the future. If you have a 75-pound dog and the association adopts a 20-pound restriction, your dog is grandfathered in. You can keep that dog. You can't get another dog that's 75 pounds, and your tenant can't get another dog after that amendment becomes effective. But that's kind of the general on that topic. It needs a little more detail in the facts.
I'm going to try and combine two questions here. One is with capital contributions. Are they permitted if it's $500? And the other one is title companies use a third party for estoppels and lien searches, and then they charge double the amount of the actual cost. A request expedited documents, which cost even more. So basically what they're saying is you're paying twice for the estoppel information. So we're back to the fee issue. So do capital contribution first and then estoppel, third parties.
Yeah, I'll tackle estoppel since I've had to live it for way too many years. Yeah, I mean, if you're contracting with the title company, then the title company uses an outside vendor and incurs that cost. That's going to be a pass-through, and I think it's something your member's going to want to take up directly with the title company. If the association just gets the contact from this lien search entity and says, here's your estoppel, and then they decide to tack on a fee for going out and getting that, then yes, it's charging it twice. But if the association's only charged the fee once and issuing it, sounds like it's more of a third-party vendor issue there. Now, if I get multiple requests, by law, I've got to answer all of them. I can't sit there and go, well, this person asked for it over here, and this person asked for it over here, and this one's first, and so I ignore the other. The law doesn't give me the discretion, because if I don't respond to an estoppel, there's a potential I waive a host of things. So if one of the things that you're going to want to do is sort of, when you get into this, who's asking for that estoppel? Because if the realtor asks for it and then the title company asks for it, I'm going to answer both of those. Maybe if I feel lucky and nice and I get both and I'm sitting at her, I may contact somebody and say, I've got two of these. Which one am I doing? Is somebody going to pull the other one? But if I get two and it's that kind of day, I'm going to answer both of those, and the fee's going to get charged twice. And it's a valid fee to be charged twice because I've got two requesters.
Capital contribution, on the other hand, is generally not allowed in a condo. There is no such thing as a capital contribution in condos. Maybe from an initial developer, if you buy as the initial purchaser, there could be something that looks like a capital contribution, but as to a turned over association, the transfer fee is limited by the statute. There shall be no fee in connection with a sale, lease, or other transfer unless approval is required by the documents, number one, and it cannot exceed the $100 per applicant. So we hear all the time from other lawyers, most oftentimes, that they want to amend documents to require capital contributions. but that's clearly not valid. And, we have these other fees somewhat masquerading as capital contributions, that you'll see the elevator fee and this fee, but those can be defended. And the capital contribution, it's not related to anything. It's not related to exclusive use. It's not authorized. So I would say with quite good certainty that that's not authorized.
Thank you. The next question I'm going to ask is from Douglas Ashley, and he's asking, who is truly responsible to get the complete set of condo docs? Is that the seller or the realtor? And then just to follow up on that, Esperanza's asking, what about if associations don't have the condo docs updated?
And in terms of whose obligation it is, under the standard FAR/BAR contract, the seller is the one that's supposed to provide all of the most current documents as part of the condo writer. So I don't think the realtor has any obligation to go down and track them. The seller should be the one providing them. I think the realtor should be talking to the seller about the time they're getting it ready to list it and saying, okay, I'm going to need to have all these. Do you have them? What are we missing? Because, as one of the worst things, and there's case law on it, is if you don't provide all of that and then you provide it later, that person can still come back in and terminate the deal prior to closing if you don't get those disclosures out of the way and they've elected to receive the documents. So have that as sort of your initial consultation when you're going to list the property of, do I have all this stuff here? And if not, dispatch your seller to go to the association and get them. Now, if they're not updated, Allison's probably going to go yell at the association in some fashion and say, hey, what? But tell us what else you're going to deal with this.
I mean, updated in terms of they don't have all of the amendments, or they're just old documents. I'm assuming that it's they don't have all of the amendments. And that could be a problem because amendments are needed to review the situation and tell you what exactly the rights are. But the association should have all of this stuff. And I wanted to also clarify on that capital contribution thing. I know I said we're here only talking about condos, which we have been, but HOA associations can charge capital contributions. And for the person that asked that question, I wanted to give a complete answer just in case you are referring to a HOA, homeowners association. They do have much, much more leeway to charge capital contributions that are authorized by their document. And there are no monetary limits on those. So it could be 500, 1 quarter, 1 year, thousands. It just depends on what those documents say, just to clarify that for everyone.
Shirley Robinson asked, as a realtor, we often look for solutions when it comes to credit score. If a buyer is financed or cash, capable to buy the condo, why can't the condo association require a certain amount of monthly dues, 1 month, 2 months, to be held in an account based on credit score that range to handle this issue? We're looking for alternatives with the credit score issue, basically. So why aren't they providing alternatives if they're saying the credit score is too low?
Well, associations, number one, never want to sort of get trapped in selective enforcement type situations. So I can see that as a concern for an association where they do try to apply their restrictions uniformly so they can keep enforcing them. So that's number one. And number two, that proposal is sort of out of the box. I've heard that proposal made, and I feel that some of my associations have tried to make that work. But I think they are hesitant to do so because we can't require upfront assessments. Sean, you can speak to that. It's not really something we can require. As to some settlement deal, sort of side deal to make this all work, I think it's plausible, but I see the associations not wanting to deal with that because of selective enforcement. And frankly, now you have to get us involved to prepare an agreement. The association has to spend money on it. So it's just not making it easy for the association, which is not a great answer, but that is part of it. What do you say about the upfront sort of deposit, Sean?
I mean, is it doable? Could we structure an agreement? Yeah, but as you alluded, there's all these costs, and then, or what are we requiring? 6 months up front? I don't know many people have that kind of liquidity that can just do that up front. And so if we're having it come in at a period of time, then great, now the person's in, but I've got the settlement agreement. So if that gets breached, I'm now litigating a settlement agreement issue as well. That there's so many pitfalls. And while it seems like, hey, this is a great way to work out this deal and make it happen, once you start adding moving pieces to it, then I get brought into it and I say, okay, well, here's where it's all going to go wrong. And now I have to draft for it. And so now I've given you a 15-page settlement agreement to address this, 3 months of money you want to give me. And it just becomes cost prohibitive all the way around and just creates technical nightmares.
I think the better way to deal with it is what I mentioned earlier, that you just try to show with other documentation, bank account balances, tax returns, whatever else there is that exists, that you try to show that you can overcome the credit score. And the proposal to give upfront funds is probably just complicated for the association.
Hi, sorry. I have a question here about if the apartment is in foreclosure process and the owner is not paying the association, can the association request that the tenant pay the association?
That's part of the law. It's been in the statute for quite a while now. It's been helpful for associations. I mentioned that earlier. So if you have the owner who's delinquent to the association, whether in foreclosure or not, they could be, $500 delinquent and anything, a fine, assessments, then the association asks me, or frankly does it in-house, sends the tenant a letter. It's a form letter in the statute that says, hey, by the way, the owner is delinquent. You better pay rent to us. And if you don't pay rent to us, we have the right to evict you. So that is why I actually feel that the credit worthiness, financial responsibility of the tenant is relevant to associations to a degree, because the associations have that right. And this has worked out quite well for associations, because a lot of times when they send that, the owner just pays because they don't want to deal with that.
And understand also that the tenant doesn't have to pay twice. The statute's clear that if the tenant pays the association, and that payment to the association of rent serves as protection from them should the owner decide, well, hey, you're not paying me, I'm going to try to evict you. The law provides a cover from there so the tenant's not having to pay two separate parties.
So how are we doing on time? Because it's already 12. Do you have more time or?
We have a couple more minutes to take some last
Okay.
minute. I
I'm
have
gonna
another
give you-
presentation at 1, but that's an hour from now.
I'm going to give you a super easy one, and then I'm going to give you a little difficult. I mean, not difficult, but more challenging. What is reptile?
Reptile is the real property, probate, and trust law section of the Florida bar. So you have the Florida bar, which is all attorneys, and then you can join individual sections. So there's real property, which is the one that I'm involved with. And then you have criminal law, you may have admiralty, trial lawyers. There's all a whole host of different sections. So it's just really a more focused group of lawyers that specialize in the world of real estate and real estate transactions and litigation.
And this one is more on the complaint side. So what if the management company is not responding to the lender's request for a condo questionnaire? And what if the condo board says that they don't accept FHA?
I mean, if the management company is not responding, there's really no mechanism in the law, to make the management company respond per se.
Not to make them respond, but CAMs, community association managers, were an unlicensed activity. And then I don't know how many years it's been, but it feels like 10 that we did actually push and state law to make them licensed. So now there's a complaint mechanism through DBPR, same as you would complain on a realtor.
Yeah, I will tell you from dealing with that, it doesn't really do much of anything. I don't think, as much as we talk about, hey, great, there's a state agency, I don't think they swing hammers. Then that's really your only mechanism, just to complain. You can't bring an action that sue the management company to say, hey, they're not responding. You don't have that.
I think it's important to note, though, that we did mention early on sunbiz.org, the division of corporations for all of these corporations here in Florida. Every association will be listed in the division's records. If you have to, write a certified letter to the mailing address for the association or the registered agent. When people say that management company is not responding, it might not be responding to a portal or an email, but people forget that sometimes it requires a letter to be sent in the mail. And even though the mail is not great these days, but that's something that you should think about doing rather than just calling or writing to a portal. You know, you need to, if it's that important, send the certified letter in the mail, and then you have a record that you did send it. And you can make a complaint to DBPR for CAM management, CAMs, but it's certainly not going to resolve your dispute or do anything in a quick manner.
And also, I think that just because it's on Sunbiz, it may not be accurate. You know, if the association switched management companies, you may be sending the letter to the prior company that was terminated 60 days ago.
It could be, but it could get forwarded to somebody, or you could write it to the board directly, who can then forward it to the manager or get to somebody. I would copy it to everybody on the list. You know, if you really want the information, send it to all board members. Do whatever you have to do to get this information.
Awesome, thank you. I'm going to ask my final question because we do respect and appreciate your time, and I'm actually going to try to roll in 2 questions. So first one is, should the owners conduct their own approval, and can the association share a credit background with the owner so that the tenant isn't paying for 2 app fees? And then on top of that, can a denial be based on a misdemeanor from several years ago, even though the tenant that's applying has clearly turned their life around?
I guess I'll take this one. A landlord, of course, can perform its own background check. It should. I would recommend that. But a lot of times we'll hear an owner landlord want to share that with the association and want the association to make a determination based on that report. If I'm the association, I'm not sure that report's going to be reliable. It's not my report. I'm going to want to run my own independent report. Of course, I have to have the authority to do so. I have to have the applicant sign off on a authorization to run credit form. A lot of the background companies that we see associations use have an application form that specifically says that the report can be shared with the owner of the unit. If the application authorization form does not provide for that language, the report cannot be shared with the owner of the unit. That's a violation of the Fair Credit Reporting Act. And that's a whole nother course on fair credit reporting. You know, if there's adverse action taken, i.e. disapprovals based on a credit report, there are notices that you have to send the applicant to say, hey, by the way, your credit report was used in this transaction and an adverse action was taken, i.e. you got disapproved, and this is how you can get a copy of your credit report. You've seen that in other types of situations, so that does apply. And there are a lot of penalties and bad things that can occur if you improperly share this information under the Fair Credit Reporting Act. We haven't seen that with associations so much, but in other businesses, I've seen a lot of cases where the entity, the association here, would be getting in a lot of trouble for sharing that type of information. So it has to be specifically disclosed and agreed to if the association does want to share that report.
And
Well,
then,
Alex,
I was gonna say, just as to the misdemeanor, I don't think many associations, at least I counsel, Alice counsel, are gonna go denying on misdemeanors. You know, maybe it's something egregious. You'd have to really see what the actual crime is. But if it's a misdemeanor from 5 years ago, I'm generally going to be advising an association that's probably not going to get upheld if we get sued.
I would agree with that. The misdemeanor, if it's something regarding violence to persons or some type of misdemeanor that's, you know, very concerning and it's severe, I think it would be legitimate, but they're typically not going to be like that. And if it occurred a long time ago, I don't know if that would be reasonable for the association. That's how I would put it.
well, Allison and Sean, I want to thank you very much for all of your input and great advice here. I think it's very valuable for our members, and Jessica would agree with this. We get a lot of questions, and clarifying it and getting on the same page and helping everyone understand is really the goal here. So thank you so much for donating your time to help our members today. We appreciate it. Jessica,
You're
do you want
very
to?
welcome.
And, you know, as we say, we have plans to do more of these, and who knows, maybe we'll come back with some sort of casual, like, think off the top of my head and scare Allison because I'm committing her to things without telling her. Maybe we'll come back with some sort of Q&A happy hour one day where we can do this in a more relaxed setting.
That sounds amazing. So again, just to mirror what Danielle said, thank you again for spending your time with us this morning. And I'm sorry for everyone who had questions that we weren't able to get through. There were tons of questions. So it's just great to see that so many people were very interested to hear your thoughts and your advice. So both of you, thank you again. Danielle, thank you again for inviting all of us to be together this morning.
Bye, you're welcome. Can't wait to come back and answer more questions. Have a good week.
And you have our contact information, so if you have specific ones, don't hesitate, and to the extent we can, we'll respond and answer and at least try and give you some guidance.
Bye.
Much appreciated. Thank you. Have a great one.